With disrespect to the council, it's to observe proper procedure. And I'd be happy to talk to the legal counsel about it so they can provide an opinion about that. Thank you.
And also, to be fair, this was not an original agenda item. It was something that just got brought up. So I don't know that he or Mr. Kennan, well, I'm sorry, Mr. Mercer would have.
Right, I understand that. I go to the planning and zoning boards, and I understand that everybody is sworn in. But what I am saying is that basically, that statement that you just stated right there could have been stated right there at the beginning. And therefore, maybe that would have brought down the tone that we're working within.
I agree.
Yes, ma'am. Did you have something related to this topic, Ms. Perkins?
About alcohol and beer and wine.
You can come to the podium.
My name is Murdine Williams. I live at 810 Hamilton Avenue Northeast. And my question is, when you say alcohol, beer and wine is one license, right? And the alcohol is a state license? Am I wrong?
I'm not a.
Because everybody's talking about alcohol in here, but beer and wine is a part of most convenience stores sell beer and wine.
Right.
And it's a different license for beer and wine than alcohol. Am I wrong?
Correct.
I mean, that's not a question.
No, I got a
that
question.
goes to me.
It's a state license, is an alcohol license, which costs more, and beer and wine is on the restaurants and bars, right? Somebody should know.
And again, I think that would be referring back to Mr. Curtis, and he already stated his position, so.
Like I said, I will have more information for all y'all.
Okay, because that's my question about the alcohol and the beer and wine. Because my mama had a restaurant bar, and they sold beer, and then they came with that, whatever percentage it was with the wine that you could sell, which we got sidetracked with that. Everybody wanna stop I'm gonna say it, the black businesses from doing what they can do, but it's okay for everybody else to do it. And I came to Live Oak, I moved back, I was born in Live Oak, but I moved back in 2015. And I stayed until 2019. And I came to y'all meetings, and it's terrible what the city of Live Oak is doing to people in their businesses. Everybody got a different guideline for whoever the person is. Because even me and Mr. Curtis had it out about the sidewalks. When I told them I wanted to see it in black and white, they went and got the paper nice to shared driveway. That came out of the whole situation with a meeting with Mr. Williams, him.
Ma'am, I'm not trying to be rude, but we've got to stay on topic, so.
No, but I'm just talking about the guidelines that everybody have different guidelines for different people.
All right, next agenda, your agenda.
6B, discussion possible council action, final reading ordinance 1538.
Ordinance number 1538, an ordinance of the City of Live Oak, Florida, amending the zoning district to 7 acres MOL of the land on the official zoning atlas of the City of Live Oak and development regulations pursuant to an application LDR 25-03 by the property owners and their authorized representatives under the amendment procedures established in the Article 3 of the Land Development Regulations, providing for a change in the assigned zoning district from commercial to neighborhood, CN, and residential office, RO, to official institution on certain lands within the corporate limits of the City of Live Oak, Florida, providing for severability, repealing all ordinances in conflict, authority, and effective date. At this time, this is a quasi judicial procedure. As stated, the next item is 6A, will be conducted as a quasi-judicial proceeding. This is the final hearing reading of the zoning ordinance, which was just read. We will open the proceedings to all those who wish to speak and will be given 3 minutes. The proposed zoning ordinance requires the city council to conduct a public hearing in quasi-judicial capacity. The city council's decision must be based on evidence and information that is presented at a public hearing, including the agenda materials. Planning board recommendations, testimony presented at the public hearing, and the deliberations of the city council. The city council must make its decision based on the evidence in the record, much like a jury must do in trial held at the courthouse. City council's decision may not be based on any information received outside this hearing process. In quasi-judicial proceedings, the city council is not allowed to take into consideration public sentiment or popularity or particular development, proposal, or request for zoning change. The city council may only consider the competent and substantial evidence that is presented to the city council. The property owner in this case, the applicant, has the burden to prove its application is consistent with the comprehensive plan and land development regulations. If this applicant meets its burden, then the Florida Supreme Court has explained the burden shifts to the governmental board to demonstrate that the maintaining an existing zoning classification with respect to the property accomplishes a legitimate public purpose. Citizens who want to participate in quasi-judicial can testify factual matters and any elements of the case that would not require specialized training or specific academic degrees. Their testimony will be considered provided their testimony is backed up by established facts, studies, or evidence that is not conjecture or based on a feeling. No expert testimony in a zoning case is perfectly permissible and can constitute substantial and competent evidence if it's fact-based. Florida courts have made it clear that mere generalization statements of oppositions are to be disregarded based in fact-based testimony can be considered competent and substantial evidence. The quasi-judicial hearing process is not a popularity contest. The members of city councils cannot consider anything that they encounter outside the public hearing on the application. Local politics can play no part in the decision-making process. In Florida, the quasi-judicial decisions made by planning officials are to be based on substantial and competent evidence and must be consistent with the comprehensive plan. Florida statute section 286.0115 provides that any person who is not authorized, prohibited by statute, character provisions, or ordinance may discuss with any of the commissioners in the merits of any matter of the city council may take action. The following procedures, which remove the presumption of prejudice, shall be followed for ex parte communications. The substance of any ex parte communications with the council member which relate to the quasi-judicial action pending before the council is not presumed prejudicial to the action if the subject of the communication and the identity of the person or group or entity with whom the communication took place is disclosed and made part of the record before the final action on this matter. The city council members may read a written communication from any person. A written communication that relates to the quasi-judicial action pending before the council shall not be presumed prejudicial to the action. Such written communication shall be made part of the record or before final action on the matter. Council members may conduct investigations and site visits and may receive expert opinions regarding quasi-judicial actions pending before the council. Such activities shall not be presumed prejudicial to the actions if the existence of the investigation, site visits, or expert opinions is made part of the record before the final action on this matter. I would ask if any of the council members has had expert communications that they would like to disclose at this time. Roll call.
Yes, please. Alternate.
Owens.
Brian Robinson, none.
Council Jefferson, none.
Campbell, no.
All those wishing to testify, speak, please stand so the clerk can administer the oath. At this time, if you do not take the oath and decide to wish to speak, you will be administered the oath when you speak.
All right. Do you swear or affirm that the evidence you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
You.
I'm Scrooge. Thank you. Development Manager, City of Live Oak. This is the second and final reading of Ordinance 1538 pertaining to the zoning change on the subject property. We have advertised the property and posted it with public hearing signage, and have not received any feedback from the community as a result of the advertising either for or against the request. The applicant did present substantial competent evidence to justify their request in regards to the comprehensive plan and the points in the land development regulations. So we recommend approval of the request based on meeting those criteria.
I'll answer questions if there are questions.
Yeah, there is a representative of the applicant here to speak on behalf of the application for any additional questions.
Still public hearing, correct?
Yes, correct.
And previously, Mr. Kinnon would close that portion out and then refer to council.
Close the portion of the public hearing.
Yeah, if nobody from the public wants to.
All right, so with the public, that we close this portion of the public hearing.
All right, you've heard from Mr. Mercer, heard from Mr. Curtis. This is the final reading. What would be the pleasure of the council?
I make a motion that we approve the final reading of ordinance 1538.
Second.
We have a motion and a second. It'll be time for discussion, if any. All right, hearing none. All in favor?
Aye.
Opposed, like sign. All right, final reading of ordinance 1538 is approved. Next item,
Item
C.
6, well, C, B now C, for ordinance 1541.
Ordinance number 1541. An ordinance of the City of Live Oak, Florida relating to public right-of-ways, making findings and vacating segments of the unimproved platted streets, alleys within the City of Live Oak, Florida as follows. That certain unnamed alley lying south of Lot 2 and between lots 4 and 5, Block 76, as shown on the plat book 76, original town of Live Oak, Florida, according to the plat thereof on file in the tax assessor's book and in the public records of Suwannee County, Florida, lying and being in section 24, township 2, south, range 13 east, providing for recitals, conveyance, conflict, and an effective date.
So this one does not require the quasi-judicial process. All right, Mr. Curtis.
Thank you, George Curtis, Development Manager. I just wanted to make a clarification of a scrivener's error that should say in the title, the plat book thereof on file, not thereif. So if we could procedurally change that as part of the motion or whatever's required, and we'll make sure in the second reading version and in the advertising that it's properly reflected.
Okay. So it'll be the pleasure of the council. If you're going to make a motion, make sure you include that verbiage what Mr. Curtis did.
Make a motion for ordinance 1541, including the amendment change to the title.
A motion
Second.
and a second. Discussion. Hearing none, all in favor? Aye. Opposed, like sign. First reading of ordinance 1541 is approved. Item D.
Item D is item ordinance 1542.
Ordinance number 1542, an ordinance of the City of Live Oak, Florida, amending ordinance number 1440, amending section 2-116 of the Code of Ordinances, City of Live Oak, Florida, providing that the salary of the city clerk and treasurer shall be adjusted from $63,360.13 to $71,360.13, providing for conflicts and severability, providing for codification, and providing for an effective date.
All right, I've heard from Mr. Mercer on the first reading of the ordinance. It will be the pleasure of the council.
I make a motion that we accept the first reading of the ordinance 1542, increasing the adjusting the salary from $63,360 to $71,360.13 for our city clerk.
Second.
All right, a motion and a second. Discussion? Hearing none, all in favor?
Aye.
Opposed, like sign.
My name was on there. I want to speak.
I'm sorry, looks like it, I thought you had on, Miss Yuli, I'm sorry. Yes, ma'am. I forgot that item numbers are changing, and I thought you said Mr. Yuli decided, so, but go ahead, yes, ma'am, go ahead. Before we vote.
Yeah, I appreciate John very much, and anybody that knows him probably would too. There's not a time that if I make a call and needing to know something, he kind of helps me out. And I come up here and I ask to see him, he takes me right back there. All of you do too, Larry. I have to say y'all are really good at it. I feel like I've been in a cat fight tonight. Reminds me of my backyard. I got 20 cats come in, stray cats come in. And I'm telling you what, I had a mess with them and I finally got them all fixed. Now I've got 20 cats fixed. So I'm hoping that there's some way this board can be fixed. Because, you know, there's better ways. Because you know as well as I do, any of you sitting up there that a house divided is not going to stand. How are we going to get anything done if we're going to scratch each other's eyeballs out? And I could say a lot more, but due to respect, Brother Larry, I'm not going to do it. I'm not going to do it, but it's sad that we get up here, and I'm not coming for entertainment. I'm coming for our community. I'm coming to try to help my community any way I can. But all this, you know, listen, God's still on the throne. Just because you've been voted in, you ain't God.
That's right.
I'm telling you. And I know that you've got power, but you need to work together, you know. You know that, Tommy Jefferson. You supposedly a man of God.
Are you calling my name?
Yeah.
I
I mean, you know.
I know what I am and I know who I am.
Yes, and I appreciate that. But like I said, you know, this is my time. We need to get along. We need to get along. It's not a pretty picture sitting out here and looking. It really is. But like I said, John's a pretty good fellow. He's helped me out. I come up here and he really helped me out about my brother. You know, where he was buried and everything. And he'd do the same thing. Larry'd do the same thing. The mayor would. I'd make sure he did. That's what I got to say about it. I got all my cats fixed. I don't have to worry about them no more, except to feed them about $200. Well, don't feed them. They said, don't feed them and they won't come. I'd feed you if you come to the house. That's just the way I am. I'm gonna feed the
I'll only
cats.
fix
So
it,
I'm
man.
gonna feed them.
Miss Pruitt. Tell Miss Pruitt to say her name. Tell her say her name.
Sure.
That's what I got to say.
What's your name? You gotta say your name first.
You want my name on it? My name is Cheryl Pruitt. I live at 125 2nd Street, Northwest Live Oak, Florida. As soon as he gets his name, they get his name up there on the city hall, I want my street named to Cheryl Street. That's
All right, yes, ma'am. All right, thank you, Ms. Cheryl. So, I think we're up to the voting portion, is that correct? Did we vote?
We already voted.
All right, so we voted.
Thank you.
It went your way. All right, item E.
Item E is council action for first reading of 1543.
All right, and we have Ms. Yvonne Scott. Would you like to speak?
My name is Yvonne Scott. I live at 7705 CR 136 Live Oak, Florida. I am a community advocate in Live Oak for 25 years. So I come to take a stance and make a stance for the young people. I am head of the Devoted 4-H Club. My Devoted 4-H Club has spent time looking at pictures and listening to stories and being molded by Mr. Yulee. And I want to share my thoughts. We admire John W. Yulee because he never served in any of his positions for recognition. That to me is the strongest message we share with the youth through his leadership and mentorship. As club leader, devoted 4-H club, I witnessed how he inspired others. My club members sharing his life story. He didn't just come and give me the mouth to talk about it. We had every newspaper article and a notebook for the kids to read, so they can see and read for their own selves. Although the District 1 City Council denied him the opportunity to serve as chief of police, he continued to serve his community faithfully for 35 years as a mailman and community leader. He always encouraged me and my children by showing us not only what he would do to serve others, but also what we could do to make a difference. And he worked alongside us to make it happen. When he took the time to share his journey with the youth, supported by newspaper articles and personal stories, it became an unforgettable lesson for our 4-H members. His example helped them see they too can make a difference, honoring the legacy of black leaders past, present, and future. And just in case you don't know, DEVOTED stands for reflects the spirit of the 4-H youth, learning, leading, and growing through leadership, citizen, and community. DEVOTED stands for determined, enthusiastic, visionary, optimistic, together, affected, and devoted. That's John Newley.
Good evening, Council, President, and Council members. Thank you for the time. I was here last month and spoke some words in favor of Robert Ford, 8896, 135th Loop, Live Oak, Florida. I was here last month and spoke in favor of naming the City Hall, old City Hall building after Mr. Yulee. So I'm not going to repeat those things, and it is following Mrs. Scott's presentation, you know, is a difficult task. But I just want to say that before coming over, I just Googled what is the criteria for naming a landmark feature after a person.